Hello, yes, I am back. As mentioned earlier, I intend to introduce to you another version of a management of CCTV evidence, whereby here we shall be talking about evidence itself. What is evidence? What is evidence according to the law? What is evidence? We are going to look at different categories and different types of evidence. I think it is important for you as a CCTV surveillance officer to know the types of evidence because your work involves gathering evidence, collection of evidence, analysis of evidence, processing of evidence, storage of evidence, among other issues. It is important for you to know what is called evidence and what can be admissible in court of law and what cannot be admissible in court of law, so that you don't find yourself on the wrong side of the law. Now, we shall briefly define evidence. Evidence is anything that you see, experience, read, or you are told that causes one to believe that something is true or has really happened. Evidence is the information which is used in court of law to try to prove something. Evidence is obtained from documents, objects, or witnesses. The available body of facts or information indicating whether a belief or a proposition is true or valid, e.g., the study finds little evidence of overt discrimination. So evidence is anything that you see, you experience, you read, or you are told that it causes one to believe that something is true or has really happened. Take note of something that you are told, because we shall also speak about hearsay as we go along. The purpose of evidence. Basically, evidence is used to prove an argument that has been made by individuals or groups that believe something to be true or a fact. Alternatively, evidence can be used to disapprove or refute a fact or argument people disagree with or hold to the false. So evidence can be used to prove. Evidence can also be used to disapprove. Take note of that. Evidence can be used to prove a fact, and evidence can also be used to disapprove a fact. For example, if somebody was assaulted in Kenya and you are the accused person and you produce an air ticket and hotel stays receipts that you are in Dubai on the material day, then your evidence is used to refute the claim that you are the one who assaulted the individual. Evidence is therefore used to back up or refute arguments. It helps people make decisions at work. Using evidence allows us to work out what is effective and what is not. So the question is CCTV evidence admissible in court? CCTV evidence, is it admissible in court? When we say admissible in court, can it be accepted in court of law and argued upon as a true evidence, either to prove or to disapprove a fact? Is CCTV digital evidence admissible in court? That is the question we are going to be asking ourselves. Rules of evidence. Let's turn our attention to what we need to know as evidence. And what we need to know as evidence about evidence are the rules of evidence. What are the rules of evidence? Evidence forms the building blocks for the investigative process. And for the final product to be built properly, evidence must be recognized, collected, documented, protected, validated, analyzed, disclosed, and presented in a manner which is acceptable to the court. It must be collected, which means retrieved or acquired. It must be documented, which means chain of custody. It must be protected, which means it must be stored properly and secured. It must be validated, which means it must be verified. It must be analyzed, it must be revealed or disclosed, and it must be presented in a manner which is acceptable to the court. In relation to CCTV surveillance, digital electronic evidence must be recognized, retrieved, stored, transmitted, processed, analyzed, and the final output presented according to company policy. So you can write that statement down. In relation to CCTV surveillance, Digital electronic evidence must be recognized, retrieved, stored, transmitted, processed, analyzed, and the final output presented according to company policy. Sources of evidence. What are the sources of the evidence? The term evidence, as it relates to investigation, speaks to a wide range of information sources that might eventually inform the court to prove or disapprove points at issue before the trial of fact. Sources of evidence can include anything from the observation of witnesses to examination and analysis of physical objects. It can even include the spatial relationships between people, places, and objects within the timeline of events. Spatial relationships. From the various forms of evidence, the court can draw inferences and reach conclusions, determine if a charge has been proven beyond a reasonable doubt. The probative value of evidence. The probative value of evidence. Each piece of relevant evidence will be considered based on its probative value, which is the weight or persuasive value that the court assigns to that particular piece of evidence when considering its value towards proving a point of fact in question for the case being heard. This probative value of evidence goes towards the judge or the judge and jury reaching their decision of proof beyond a reasonable doubt in criminal court or proof within a balance of probabilities in the civil court. Moving on, we see that the type of evidence number one, or category of evidence number one, is eyewitness evidence. What you saw or what one sees when one sees an occurrence or an object. A competent, compellable, independent eyewitness with excellent physical and mental capabilities who has seen the criminal event take place and can recount the facts will generally satisfy the court and provide evidence that has high probative value. If you are determined to be in a good, excellent physical condition and a good mental capabilities, and you have witnessed somebody shooting another person, then you testify in court, then your evidence will have high probative value. The evidence will generally be accepted by the court as admissible, and it will be used to make a decision towards the accused person. So evidence by a eyewitness has got high value in court. Just remember that evidence by a eyewitness who saw something happen has got very big high weight in the court of law. The judge will definitely listen to this evidence. Assessing the probative value. In assessing the probative value of eyewitness evidence, the court will consider several factors. The witness type as either eyewitness or corroborative witness. Corroborative witness is a witness who is supporting the witness by another witness. For example, a witness says, I saw this guy shooting this lady. And then another guy says, I was also nearby, but from a distance, and I also saw it happening. So what A says actually happened. That is corroborative witness. And then the witness competency to testify. Are you competent? One who has sufficient mental capacity. Take note, mental capacity plays a very big role in matters before the court, because you can actually be acquitted if it is concluded that you are not in the proper mind. And then one who has sufficient mental capacity to perceive, remember, narrate to the incident he has observed. And then the witness compellability to testify may be lawfully be required to give evidence. You may be by law required to give evidence. And then the level of witness independence from the event. There are other situations where you want to give an evidence, but you are attached to the event. You are compromised. You have got an interest in the case. So your level of independence from the event matters also in assessing the probative value. And then the witness credibility based on assessment of physical limitation. Witness credibility based on assessment of physical limitations. And then we go to another type of evidence, which is also of great importance to the court, and this is a physical evidence. These are items the court can see and examine to interpret the facts in issue for proof beyond a reasonable doubt. These are items the court can see. For example, a knife, for example, a gun, for example, pieces of clothing, a jacket that was found at the scene, an ID card, a mobile phone. These are items that the court can see and examine to interpret facts in issue for proof beyond a reasonable doubt. Physical evidence can include just about anything, such as weapons, fingerprints, shoe prints, tire marks, tool impression, hair, fiber, or body fluids. If you join us in future for a course in investigation skills, then you will be able to understand at a deeper level this kind of physical evidence. This kind of physical exhibits or evidence can be examined and analyzed by experts who can provide the court with expert opinions that connect the item of evidence to a person, place, or the criminal event. Medical experts, vocational experts, forensic experts, financial experts, security experts, mental health experts, parenting experts are some of the experts we are talking about. So if you study more in your career, then you can choose to play a role in one of those very interesting fields as an expert. Number 3, we talk about relevant evidence. Relevant evidence. Evidence is relevant when it has applicability to the issue presented in the case. Relevant evidence includes both direct evidence and indirect circumstantial evidence. For either direct or indirect circumstantial evidence to be considered relevant to the court, it must relate to the events of the offense that need to be proven. It must relate to the elements of the offense that need to be proven. So you can just not, for example, if it is a murder case that is being investigated and you produce evidence that is not relevant to the case. For example, you produce an eyewitness who was not at the scene, who was far away based on other evidence, then that evidence is not relevant to the case. That the witness is not relevant to the case. We also talk of if the evidence does not relate to proving the place, time, identity of the accused or criminal acts within the offense itself, the evidence will not be considered relevant to the charge. So if the evidence does not relate to proving the place, time, identity of the accused or criminal acts within the offense itself, the evidence will not be considered relevant to the charge. A fact is relevant when it helps to prove an issue. So a fact is relevant when it helps to prove an issue. So even you, as a CCTV surveillance officer, before you submit evidence, you must consider that this footage or this captured photo is a fact that is relevant to prove an issue that is in question. For example, if you are investigating an access control issue, then you produce a photo of another area like a boiler room, which is not the access control main gate, then that photo is not relevant to the charge or relevant to the fact in issue. We also talk of direct evidence. Direct evidence is evidence that will prove the point in fact without interpretation of circumstances. It is any evidence that can show the court that something occurred without the need for the judge to make inferences or assumptions to reach a conclusion. An eyewitness who saw the accused shoot a victim will be able to provide direct evidence. That one is self-explanatory. Direct evidence. Directly it points to the issue that happens. It proves the fact that is being investigated without further inferences, without further assumptions, without further questions. Similarly, a security camera showing the accused committing a crime or a statement of confession from the accused admitting to the crime could also be considered direct evidence. A security camera showing the accused committing a crime or a statement of confession from the accused admitting to the crime could be considered direct evidence. So when we talk about CCTV footages, remember this can be considered as direct evidence if the camera captured a person actually committing the crime. Circumstantial evidence. Circumstantial evidence is what we call indirect evidence, also called circumstantial evidence. It is all other evidence, such as the fingerprint of an accused found at the crime scene. Indirect evidence does not by itself prove the offense, but through interpretation of the circumstances and in conjunction with other evidence may contribute to a body of evidence that could prove guilt beyond a reasonable doubt. Circumstantial evidence attaches you to the scene. For example, if something happened and your ID card is found at the scene, then definitely the police will be looking for you. Though you might not be the one who committed the crime, because other people would have stolen your ID, but then you have to appear before court to remove yourself from that situation. Or your piece of clothes is found somewhere, and it is known that you are the one who is using this cloth, this t-shirt or this jacket, then that would be circumstantial evidence attaching you to the crime. So circumstantial evidence demonstrates the spatial relationships between suspects, victims, timelines, and the criminal event. Take note of that. Circumstantial evidence demonstrates the spatial relationships between suspects, victims, timelines, and the criminal event. Inculpatory evidence. Inculpatory evidence is any evidence that will directly or indirectly link an accused person to the offense being investigated. It links you directly or indirectly to the offense being investigated. For an investigator, inculpatory evidence can be found in the victim's complaint, physical evidence, witness account, or the circumstantial relationships that are examined, analyzed, and recorded during investigative process. It can be anything from direct evidence of an eyewitness who saw the accused committing the crime to the circumstantial evidence of a fingerprint found in a location connecting the accused to the victim of the crime scene. Evidence which attaches the accused to the offense. Evidence which attaches the accused to the offense. That one is what we call inculpatory evidence. And then there is exculpatory evidence. It removes you from the offense. That is 6. Exculpatory evidence. Exculpatory evidence is the exact opposite of inculpatory evidence in that it tends to show the accused person or the suspect did not commit the offense. For example, I mentioned earlier, a murder case is committed in Kenya or an assault case with a serious bodily harm, and you are the accused person, and you provide evidence that on that material day you are out of the country, then that one was what we call exculpatory evidence. The evidence that you produce to show the air ticket, the hotel charge receipts shows that you are attending a seminar in New York, and now you are being accused that you assaulted somebody in Nairobi, then that is what we call exculpatory evidence. It removes you from the offense. If it is possible to find exculpatory evidence that shows the suspect is not responsible for the offense, it is helpful for police because it allows for the elimination of that suspect and the redirecting of the investigation to pursue the real perpetrators. Exculpatory evidence is very, very important to the investigative agencies because it ensures that people do not end up in a court of law when they have not committed these crimes. However, in Kenya, you know the situation very well. So many people are suffering in prison for offenses they did not commit because they lacked exculpatory evidence. They could not remove themselves from the scene. Corroborative evidence, I spoke about that. The term corroborative evidence essentially refers to any type of evidence that tends to support the meaning, validity, or truthfulness of another piece of evidence that has already been presented to the court. A piece of corroborative evidence may take the form of a physical item such as a DNA sample from an accused matching the DNA found on a victim, thus corroborating a victim's testimony. Corroborative evidence might also come from the statement of one independent witness, providing testimony that matches the accused of events described by another witness. Corroborative evidence supports evidence already submitted by another person in terms of validity or truthfulness. Witness evidence. We go back to eyewitness evidence. So there's eyewitness evidence and there is witness evidence. Witness evidence is evidence obtained from any person who may be able to provide the court with information that will assist in adjudication of the charges being tried. So you see the difference. Eyewitness, you saw an incident happen. You saw an object. But witness evidence, any person who may provide the court with information that will assist in the adjudication of charges being tried. This means the witnesses are not only persons found as victims of a crime or on-scene observers of criminal event. They may also be persons who can inform the court on events leading up to the crime or activities taking place after the crime. So it is not, when you talk about witness evidence, it doesn't mean only eyewitness. It means that maybe you have information that you can share with the police that can lead to the arrest of the perpetrators of a particular crime that is before the court. And then, consequently, every police officer involved in the investigation and every person involved in the handling, examination, and analysis of evidence to be presented in court is a potential witness. So handling of CCTV digital evidence puts you in the middle of all these issues. You become a potential witness. Handling of CCTV, processing of CCTV digital evidence, transmission of CCTV physical evidence brings you to the scene as a potential witness. And then we can also move to hearsay evidence. Hearsay evidence is evidence that a witness has had a communication from another party. In addition to verbal communication, legal interpretations of the meaning of hearsay evidence also include other types of person-to-person communication, such as witness statements or even gestures intended to convey a message. As defined by John Hopinka in his book, The Law of Evidence, hearsay evidence is generally considered to be inadmissible in court at the trial of an accused person for several reasons. You all know that hearsay evidence in most cases is not admissible in court. But let's look at some an additional understanding on why hearsay evidence is not admissible in court. Why hearsay evidence is inadmissible in court? When we say inadmissible, we say in most cases it is not admitted in court. There are only small situations where it can be admitted, and we shall discuss that. The court generally applies the best evidence rule to evidence being presented, and the best evidence would come from the person who gives the first-hand account of events, like a witness, an eyewitness, or a person who provides direct evidence. The original person who makes the communication that becomes hearsay is not available to be put under oath and cross-examined by the defense. That is why hearsay evidence is not admissible, because the original person who makes the communication that becomes hearsay is never in court to be put under oath and cross-examined by the defense. In hearing the evidence, the court does not have the opportunity to hear the communication firsthand and assesses their demeanor to gauge their credibility and assess their behavior to gauge their credibility. And then exclusion of evidence by the court. The court may exclude some evidence based on the fact that in hearing any case, the court has the authority to either accept or exclude any piece of evidence being presented. An evaluation is applied to all evidence to determine if it will be admissible or excluded. The types of evidence that can be admitted or excluded range from the physical exhibits found at the crime scene to the accounts of events provided by witnesses to a confession taken from a suspect. And then, is CCTV digital evidence admissible in court? Yes. CCTV digital evidence is admissible in court. It is imperative. It is imperative. It is imperative the CCTV system is compliant with the restrictions under the Data Protection Act in order for the evidence to be admissible in court. For digital evidence to appear at court and be legally admissible, the evidence must be authentic, accurate, complete, and convincing to the jury. Summary. Evidence is a key feature to any investigation. So it is important for investigators to understand the various legal definitions of evidence, the various types of evidence, and the manner in which evidence is considered and weighed by the court. Evidence forms the building blocks of the investigative process, and for the final product to be built properly, evidence must be recognized, collected, documented, protected, validated, analyzed, disclosed, and presented in a manner that will be acceptable to the court. We already said that. Evidence continues to be a key element for the consideration in development of proper investigative processes. So you as a CCTV surveillance officer, you must know what is evidence and what is not evidence. What can I present in court? And what can I present to my manager that will not put me in a compromising situation? You should be, as I said in the other presentation, a professional security surveillance officer. You should understand that if I present this evidence to my manager, then it will be invalid because it is hearsay. It is not from recorded images. They are not captured videos or photos or images. So this evidence will not be accepted. It is a very serious crime. It is a very big embarrassment for you to present evidence accusing other people, and then the evidence is inadmissible before your own manager or before the general manager. So that is an area that you need to watch. You need to understand what can we term as evidence based on what we have discussed, and what can we not include as evidence, because as CCTV surveillance officers, we are investigators. We investigate issues using the system, using CCTV systems. So you must be able to properly put into the correct context the types of evidences that exist. And then long descriptions, evidence, types, and long description. There are two types of evidence, direct and indirect. Direct evidence will prove a point in fact without interpretation of circumstances. Indirect evidence is circumstantial evidence. Interpretation is required to prove a point in fact. So direct evidence will prove point in fact without interpretation of circumstances. Indirect evidence is circumstantial evidence. Interpretation is required to prove the point. With those few remarks, I once again say thank you for joining Brand Institute of Forensics and Security to study with us. I am very positive and very confident that this certification and this course will add value to you as an effective CCTV surveillance officer. In future, if you get time, you may also join us for other courses that we conduct online, or other courses that we conduct physically at the institute. And I am very positive and very sure that you will learn a lot about this subject of security and the subject of CCTV surveillance. So thank you so much, and I wish you the best of luck. Thank you, and bye-bye.